And joining us now is Robert Ray, a former independent counsel during the Whitewater investigation, a member of former President Trump's legal team during his first impeachment trial. Thanks so much for coming in, Robert.
Nice to be with you.
As you observe this cross-examination that's now into day two, now into almost the second hour of today's specific testimony, do you see any missteps so far by Trump's defense team?
No, ladies and gentlemen, I think the commentary is missing the boat. This is not your usual cross-examination with regard to impeachment of the government's cooperating witness. You have a situation in which Todd Blanche has gotten the witness to acknowledge voluntarily that he perjured himself during his plea allocution. That virtually never happens. And if it does happen, I was always taught as a prosecutor that essentially renders the witness's testimony valueless. And not only has he acknowledged that he perjured himself during his plea allocution, which this is not like
what do you mean by plea allocution, if you could just for everybody?
It's not a detour into his 2018 guilty plea before a federal judge. Not only did he acknowledge that the plea was not voluntary and he pleaded guilty, most importantly, to crimes that he believes still that he did not commit. One of which is suspiciously like, or two at least are suspiciously like, the charges that Donald Trump is charged with in this case and about which this witness is testifying. So I have to tell you, you can try to characterize this testimony as just the usual defense lawyer cross-examination with regard to bias and veracity, but this is, I will say, extraordinary. I've done this for a very long time. It is very unusual to have a witness back up. They back up on questions of, you pleaded guilty and some question about voluntariness because the government was going to put the hammer on me. In my experience, and I was a prosecutor for a long time, the only place you ever got close to the line is when you start to threaten family members, because you always know that if you do that, and I will tell you that I did it. And in some cases, I thought long and hard about it. And in retrospect, I thought about it with some regret. The fear that if you apply that kind of pressure, you can get somebody to do the worst thing possible, which is to plead guilty to something they didn't do.
Well, I hear what you're saying, Robert, but let me just interject.
That's a problem for a prosecution.
But this isn't new. I mean, what you're describing, what he admitted to, is something that's already been out there, that Cohen has lied under oath, he's lied when it comes to a plea deal.
It's not just the first and only time.
It's not.
You're saying that you yourself.
It's not just a lie under oath, which it is. It's also a lie to plead guilty to something that he believes that he didn't commit. And it's not going to be lost on the jury when they're asked to deliberate over essentially what are the same charges against the former president. So I have to tell you, that's a much more catastrophic thing that I think than you're letting on. And it is going to be a major point of contention, I think, in summation. And the other thing that I will say is that what's going on right now relates to this whole question of the pardon, which sounds like a bit of a sideshow. But remember, what we're likely to see is that Robert Costello is going to take the stand in the defense's case. And basically is
that what you've been told? Because that's not what our understanding is.
I don't know, but it seems like the questions that were set up to Costello is going to come in and basically say that everything you just heard, that you heard during the testimony of Michael Cohen, is false.
So what are you basing, and I'm just wondering, what are you basing?
I'm basing it on the questions that are being asked. It seems
not on anything
I know, but on the questions that are being asked. It seems to me to be a setup to what the defense's case is likely to be. I think there are going to be two areas principally that they'll focus on. One is going to be expert testimony with regard to the Federal Election Campaign Act and what is and isn't a contribution and an expenditure. And it won't get into questions that are too close to the issue about whether or not you could prosecute for that. But that won't matter. It'll just be about expert testimony about how you handle, from a financial perspective, those issues. I think the second thing is you're likely to hear accounting testimony with regard to how book entries are made in connection with corporate records. And the third thing is that I think Costello is going to testify and impeach the testimony of Michael Cohen. That's what I think is going to happen.
I think to your point, at least what was lacking on the prosecution's case was that background in terms of the election law and the financing. I think that is lacking, which would be a very solid place to move as in defense,
right?
Because they need to set it up for summation. this is, I think, a very valuable point. Whether Costello testifies, that's yet to be seen. I think maybe not.
And there may be ways to do that without actually having him testify. But I think I read the cross-examination essentially as a preview of there's something more to come. They wouldn't be asking those questions. Todd Blanche wouldn't be asking those questions unless he's going to have evidence in the defense case to go along with it.
I just want to come back to what you said at the beginning, which is you felt like there was this major moment that happened that perhaps we didn't catch because we don't know as much of the law as you do. But I'm wondering if the jurors would have caught that as well. Did you see it, Chuck, the same way that Robert saw it?
No, and I think it goes to the notion that this is a little bit more art than science. We may all have cross-examined Michael Cohen, and we may all have done it in a different way because, we have a different goal at the end. I still hew to the notion that he is more like most cooperating witnesses that I've seen, and I've seen a lot as a prosecutor, and that they're going after a traditional bias, inconsistency, convicted perjury, sort of approach. Maybe I'm wrong. I'm wrong all the time.
If a prosecutor had their hooks into a witness, which they typically do because there's a sentence that is hanging over the witness, and that's not the case here. I mean, he served his sentence. They don't have that kind of leverage. If that person were a cooperating witness and that person testifies at a trial that they pleaded guilty to a crime they didn't commit, that person would lose the benefit of their cooperation agreement because that would be perjury during a plea allocution, which is an automatic out for the prosecution to say you have violated the plea agreement.